You know, sometimes the biggest fights start over the smallest things. This is a story about a driveway, but really, it's about so much more. It's about rules, it's about community, and it's about that fuzzy line between your property and your neighbor's rights. What started as a simple homeowner's request for a little more parking space, well, it spiraled into a legal war that dragged on for nearly a decade and cost a ton of money. So how on earth did a driveway extension become this massive battle between a homeowner and her HOA?
And that's really the big question, isn't it? It seems almost unbelievable. In this explainer, we're going to break down this case out of Phoenix, Arizona. And it's a perfect example of just how fast these little neighborhood disagreements can blow up. It really shows how the very rules designed to keep a community looking nice can also lead to years of bitterness and, yeah, a lot of legal fees.
Okay, so let's rewind the clock. Our story kicks off way back in 2015. A homeowner, Bernadette Bennett, decides she wants to make a few changes to her front yard in the Keystone community. A simple request, right? Well, that simple request would turn out to be the first shot fired in a conflict that would drag on for years to come. Let's trace this back to the very beginning. So in March of 2015, Ms. Bennett sends in a request to add some pavers to her driveway. At first, everything seems to be going smoothly, but then things take a sharp turn. The HOA's advisory committee does a complete 180 on their initial approval, and the board denies the request. But Ms. Bennett, she decides to go ahead and install the pavers a couple of years later anyway, which, as you can guess, set off a chain reaction that ultimately landed everyone in a formal legal hearing.
Okay, so check this out, because this is where it starts to get weird. At 1:52 p.m. on March 25th, a key guy on the Architectural Advisory Committee shoots off an email. In it, he says the committee unanimously approved the request. All 3 members were on board. It looked like a done deal, right? Green light?
But just 7 hours later, that same committee member sends another email. This time, he's completely flipped his position. And the reason? He noticed the plan included the words additional parking. That one little phrase became the entire justification for the HOA's denial and, believe it or not, the absolute core of the legal fight that followed.
So here's the kicker. Even though the advisory committee was split 2-1 in favor of the project, the HOA board went ahead and issued a formal denial. And the official reason wasn't about the materials, it wasn't about the size, it was about the intent to create more parking. And just like that, the battle lines were drawn.
So for a few years, things kind of simmered. But then we jump forward to 2022, and everything just comes to a head. Ms. Bennett makes even more changes to her driveway, and this time the HOA was not messing around. They decided it was time to take formal action, and this whole dispute entered a much more serious phase.
So in early 2022, the homeowner doubles down. The pavers and the turf that were there, they get ripped out and replaced with a solid concrete driveway extension. Now, in the eyes of the HOA, this wasn't just some unapproved weekend project. This was a direct, clear violation, and they felt they just couldn't ignore it anymore. Now, to really get why the HOA was so dug in, you have to understand something called the 35% rule. And interestingly, this rule didn't even come from the local Keystone HOA. It came from their master association. Think of it like a pyramid. The master association is at the top making big rules for everyone, and Keystone is a smaller community below that has to follow those rules. And this particular rule was all about aesthetics, making sure front yards didn't just become giant parking lots. And the HOA was convinced Miss Bennett's new driveway blew right past that 35% limit. I mean, the wording of the rule itself is pretty black and white, right? It's clear, it's specific. And the HOA argued that this rule, which had been sitting in the community documents for years, was the legal backbone of their entire case against her. They finally had something concrete, literally, to point to. So, armed with this 35% rule, the HOA started to build its case, step by step. First, they send a violation notice. Then, and this is a really important legal step, they got formal permission from the Master Association to enforce the rule themselves. After that, the fine letters started showing up. And when nothing changed, they filed the official petition that took this whole thing out of the neighborhood and into a formal hearing room.
So on November 19th, 2024, almost a full decade after that first request, both sides finally get to make their case in front of an administrative law judge. And as you can imagine, the testimony revealed 2 completely different realities, 2 totally different interpretations of the exact same events.
The homeowner's whole defense basically boiled down to this: you waited too long.
Her argument was that the modified driveway had been there in some form for over 4 years, and she never got a single complaint or violation notice. But the HOA's argument was just as simple. A rule is a rule. They said their job is to enforce the documents no matter how much time has passed.
So, Miss Bennett's main legal defense was this concept called latches. It's a fancy legal term, but the idea is actually pretty simple. It basically means if you wait too long to complain about something, if you sleep on your rights, so to speak, you might lose the right to complain at all. So the big question for the judge was, did the HOA wait so long that it would be unfair to make her tear out her driveway now?
During the hearing, the homeowner's lawyer really zeroed in on that bizarre decision from back in 2015. He kept asking how the board could just ignore a 2-to-1 vote for approval from its own committee. This was a huge part of their strategy, to show that the whole process was flawed right from the start.
And the HOA's response? Well, it was a real bombshell. A witness for the association actually testified under oath that the board didn't even consider the 2-to-1 vote. They said that all that mattered was that one person on the committee thought it was a violation. That single dissenting voice was enough to trump the majority. I mean, that admission was a huge moment in the case. So, after listening to all the testimony, sifting through almost 10 years of emails, photos, and documents, the administrative law judge finally issued a decision on December 9, 2024. This long, messy, complicated dispute was about to have an official ending.
So, after all that, who won? Was it the owner who just wanted a bigger driveway? Or was it the HOA, determined to enforce the rules no matter what?
The judge's decision was a slam dunk for the Homeowners Association. The violation was confirmed. The homeowner's main defense, latches, was shot down. The judge officially declared the HOA the prevailing party and ordered the homeowner to bring her property into compliance with the rules.
And this right here is the legal reasoning that really sealed the deal. What the judge is saying here is that, yeah, the HOA waited a while, but the homeowner couldn't prove that the delay was unreasonable or that it actually harmed her in a legally recognized way. That was the nail in the coffin for her case.
And in the end, on top of having to fix her driveway, the homeowner was also ordered to pay the HOA $1,500. That was just to cover the fee they had to pay to file the case in the first place.
So what do we take away from this? The Keystone driveway dispute is a lot more than just a wild story. It's a real-life case study in just how complicated living in a community with rules can be. It forces us to ask some really tough questions, right? Like, how much say should your neighbors have over what you do with your own property? And where do you find that perfect balance between keeping the neighborhood looking good and, just letting people live their lives? There are no easy answers here, but as this case shows, the stakes can be incredibly high.